Good evening, everybody. How is everyone doing today? Got a new setup, and part of it just fell down as I started going live. The flag did not stay up on that side, but that's okay. We will fix that before the next stream, I promise you all. Tonight, we have very interesting case material. And if you believe that, there's a bridge in Brooklyn I want to sell you. No, we have the jurisdiction of courts over persons and property from conflict of laws. Pretty long reading, 3 cases to cover. Let's just get into it. So, Part A is consent and waiver. Here we're determining how courts have jurisdictions over people or property to make rulings if the people or property are in separate and differing jurisdictions, which have different laws governing their liability or property. So let's go into it. Phillips Petroleum Company versus Schutz, U.S. Supreme Court decision from 1985. Reduced to its essentials, petitioner's argument is that unless out-of-state plaintiffs affirmatively consent, Kansas courts may not exert jurisdiction over their claims. Petitioner claims that failure to execute and return the request for exclusion provided with the classic notice cannot constitute consent of the out-of-state plaintiffs. Thus, Kansas courts may exercise jurisdiction over these plaintiffs only if the plaintiffs possess the sufficient minimum contacts with Kansas, as that term is used in cases involving personal jurisdiction for out-of-state defendants. Look at International Shoe Company versus Washington, Schaefer versus Heinter, Worldwide Volkswagen Corp versus Woodson, which are all classic Civ Pro jurisdiction minimum contact state case law. All right, since Kansas has no pre-litigation contact with many of the plaintiffs and leases involved, petitioner claims that Kansas has exceeded its jurisdictional reach and thereby violated the due process rights of the absent plaintiffs. Although in cases like Schaefer and Woodson, which petitioner relies on for a minimum contacts requirement, all dealt with out-of-state defendants or parties in the procedural posture of a defendant. Here, petitioner claims that the same analysis must apply to absent class action plaintiffs. In this regard, petitioner correctly points out that a choice of action is not a constitutionally recognized property interest possessed by each of the plaintiffs, citing Mullane versus Central Hanover Bank and Trust Company, a U.S. Supreme Court case of 1950. An adverse judgment by Kansas courts in this case may extinguish the choice in action forever through res judicata. Such an adverse judgment, petitioner claims, would be every bit as onerous to an absent plaintiff as an adverse judgment on the merits would be to a defendant. Thus, the same due process protections should apply to absent plaintiffs. Kansas should not be able to exert jurisdiction over the plaintiff's claims unless the plaintiffs have sufficient minimum contacts with Kansas. We think petitioner's premises are in error. The burdens placed on a state by an absent class action plaintiff are not the same order or magnitude as those it places upon with an absent defendant. An out-of-state defendant summoned by a plaintiff is faced with the full powers of the forum state to render judgments against it. The defendant must generally hire counsel and travel to the forum to defend itself from the plaintiff's claim or suffer a default judgment. The defendant may be forced to participate in extremely and often costly discovery and will be forced to respond in damages or comply with some other form of remedy imposed by the court should it lose the suit. The defendant may also face liability for court costs and attorney's fees. These burdens are substantial, and the minimum contacts requirement of the Due Process Clause prevents the forum state from unfairly imposing them against a defendant. A class action plaintiff, however, is in quite a different posture. The court noted this difference in Hansberry versus Lee, a 1940 Supreme Court case, which explained that a class or representative suit was an exception to the rule that one could not be bound by judgment in personam unless one was made fully party in the traditional sense, citing Pennoyer versus Neff, 1878 Civ Pro case establishing in personam jurisdiction. As the court pointed out in Hansberry, the class action was an invention of equity to enable it to proceed to a degree in suits where the number of those interested in the litigation was too great to permit joinder. The absent parties would be bound by the decree as long as the named parties adequately represented the absent class and the protection of the litigant or prosecution of the litigant was within the common interest. U.S. Supreme Court decision, Hansberry. The Hansberry holding is what they're citing to. Modern plaintiff class actions follow the same goals, permitting litigation of a suit involving common questions where there are too many plaintiffs for proper joinder. Class actions may also permit the plaintiffs to pool claims which would be uneconomical to litigate individually. For example, this lawsuit involves claims averaging about $100 per plaintiff. Most of the plaintiffs would have no realistic day in court if a class action were not available. In sharp contrast to the predicament of a defendant hailed into an out-of-state forum, the plaintiffs in this suit are not hailed in anywhere to defend themselves upon the pain of a default judgment. A plaintiff class in Kansas and numerous other jurisdictions cannot be first certified unless a judge, with the aid of the named plaintiffs and defendants, conducts an inquiry into the common nature of the named plaintiffs and the absent plaintiffs' claims, the adequacy of their representation, the jurisdiction possessed over the class, and any other matters that will bear upon the proper representation of the absent plaintiff's interest, citing Federal Rules of Civil Procedure 23 and Kansas Statutes Section 66 Tac 223. Unlike a defendant in a civil suit, a class action plaintiff is not required to fend for himself. See another Kansas statute of the same section, subsection D. The court and named plaintiffs protects his interests. Indeed, the class action defendant itself has a great interest in ensuring that the absent plaintiff's claims are properly before the forum. In this case, for example, the defendant sought to avoid class certification by alleging that the plaintiffs that are absent would not be adequately represented and were not amenable to the jurisdiction. The concern of the typical class action rules for the absent plaintiffs is manifest in other ways. Most jurisdictions, including Kansas, require that a class action, once certified, may not be dismissed or compromised without the approval of the court. In many jurisdictions, such as Kansas, the court may amend the pleadings to ensure that all sections of the class are represented adequately. Besides this continuing solicitude of their rights, absent plaintiffs, class members, are not subject to burdens imposed upon defendants. They need not hire counsel or even appear. They are almost never subject to counterclaims or cross-claims or liability for any fees or costs. Absent plaintiff class members are not subject to coercive or punitive remedies, nor will an adverse judgment typically bind an absent plaintiff for any damages, although a valid adverse judgment may extinguish any of the plaintiff's claims which are litigated. Unlike a defendant in a normal civil suit, an absent class action plaintiff is not required to do anything. He may sit back and allow the litigation to run its course, content in knowing that there are safeguards provided for his protection. In most class actions, an absent plaintiff is provided at least with an opportunity to opt out of the class, and if he takes advantage of that opportunity, he is removed from the litigation entirely. This was true of the Kansas proceedings in this case. The Kansas procedure provided for mailing of a notice to each class member by first-class mail. The notice, as we have previously indicated, described the action and informed the class member that he would appear in person or by counsel, in default of which he would be represented by the named plaintiffs and the named plaintiffs' attorneys. The notice further stated that class members would be included in the class and bound by judgment unless they opted out by executing and returning a request for exclusion that was included with the notice. Petitioner contends, however, that the opt-out procedure provided by Kansas is not good enough and that an opt-in procedure is required to satisfy the Due Process Clause of the 14th Amendment. Insofar as plaintiffs who have no minimum contacts with the forum state are concerned, an opt-in provision would require that each class member affirmatively consent to his inclusion within the class. Because states place fewer burdens upon absent class plaintiffs than they do upon absent defendants in non-class suits, the Due Process Clause need not and does not afford the former as much protection from state court jurisdiction as it does the latter. The 14th Amendment does protect persons, not defendants. However, so absent plaintiffs as well as absent defendants are entitled to some protection from the jurisdiction of a forum state which seeks to adjudicate their claims. In this case, we hold that a forum state may exercise jurisdiction over the claim of an absent class action plaintiff, even though that plaintiff may not possess the minimum contacts with the forum state which would support personal jurisdiction over a defendant. If the forum state wishes to bind an absent plaintiff concerning a claim for money damages or similar relief at law, it must provide minimal procedural due process protection. The plaintiff must receive notice plus an opportunity to be heard and participate in the litigation, whether in person or through counsel. This notice must be the best practical, reasonably calculated, under all circumstances, to appraise interested parties of the pendency of the action and afford them opportunity to be present opportunity to present their objections. That's from the Mulaney case, a 1974 case. The notice should describe the action and the plaintiff's rights in it. Additionally, we hold that due process requires a minimum that an absent plaintiff be provided with an opportunity to remove himself from the class by executing and returning an opt-out or request for exclusion form to the court. Finally, the due process clause, of course, requires that the named plaintiff at all times adequately represent the interests of all the absent class members from their Hansberry decision. We reject petitioner's contention that the due process clause of the 14th Amendment requires that absent plaintiffs affirmatively opt into the class rather than be deemed members of the class if they do not opt out. We think that such a contention is supported by little, if any, precedent, and that it ignores the differences between class action plaintiffs on the one hand and the defendants in a non-class action civil suit on the other. Any plaintiff may consent to jurisdiction, citing Keaton versus Hustler Magazine Incorporated 1984 case. This essential question, then, is how stringent the requirement for a showing of consent will be. We think the procedure followed by Kansas, where a fully descripted notice is sent out first-class mail to each class member with an explanation of the right to opt out, satisfies due process. Requiring a plaintiff to affirmatively request inclusion would probably impede the prosecution of those class actions involving an aggregation of small individual claims, or a large number of claims are required to make it economical to even bring the suit. The plaintiff's claim may be so small or the plaintiff so unfamiliar with the law that he would not file suit individually, nor would he affirmatively request inclusion in the class if such a request were required by the Constitution. If, on the other hand, the plaintiff's claim is sufficiently large or important that he wishes to litigate it on his own, he would likely have retained an attorney or have thought about filing suit and should be fully capable of exercising his right to opt out. In this case, over 3,400 members of the potential class did opt out, which belies the contention that opt-out procedures result in guaranteed jurisdiction by inertia. Another 1,500 were excluded because a notice and opt-out form was undeliverable. We think that such results show that the opt-out procedure provided by Kansas is by no means pro forma, and that the Constitution does not require more to protect what must be a somewhat rare species of class members who is unwilling to execute the opt-out form, but whose claim is nonetheless so important that he cannot be presented or presumed to consent to being a member of his class by his failure to do so. Petitioner's opt-in requirement would require the invalidation of scores of state statutes and of the class action provision of the Federal Rules of Civil Procedure. And for the reasons stated, we do not think that the Constitution requires a state to sacrifice the obvious advantages in judicial efficiency resulting from the opt-out approach for the protection of the rara avis portrayed by petitioner. We therefore hold that the protection afforded to the plaintiff class members by the Kansas statute satisfies the due process clause. The interests of the absent plaintiffs are sufficiently protected by the forum state when those plaintiffs are provided with a request for exclusion that can be returned within a reasonable time to the court. But both the trial court and the Supreme Court of Kansas held the class received adequate representation and no party disputes that conclusion here. We conclude that Kansas court properly asserted personal jurisdiction over the absent plaintiffs and their claims against petitioner. Denied. All right. So that was consent. Basically, you have, as a class action suit, you've consented unless you file the opt-out or the exclusionary thing, at which point in time you sever yourself from the class, and then the court doesn't have jurisdiction to hear your part of that claim. You must pursue it individually through your own cost and to get your own remedy. All right. Now we're on to subpoint 2, which is waiver. So I'm imagining in this case, someone's going to waive the jurisdiction into this forum state. Insurance Corporation of Ireland versus Compagnie de Bauxites de Guinee. Guinea, I guess. Justice White delivered the Supreme Court's opinion in this case, the 1982 case. Justice White writes, Rule 37B of the Federal Rules of Civil Procedure provides that a district court may impose sanctions for failure to comply with discovery orders, included among the available sanctions is, quote, in order that the matters regarding which the order was made or any other designated facts shall be taken to be established for the purpose of the action in accordance with the claim of the party obtaining the order. I believe this is the inverse inference rule. Let's see. There's Federal Rules of Procedure 37B2A. The question presented by this case is whether the rule is applicable to facts that form the basis for personal jurisdiction over a defendant. May a district court, as a sanction for failure to comply with a discovery order directed at establishing jurisdictional facts, proceed on the basis that personal jurisdiction over the recalcitrant party has been established? Petitioners urge that such an application of the rule would violate due process. If a court does not have jurisdiction over a party, then it may not create that jurisdiction by judicial fiat. They contend also that until a court has jurisdiction over a party, that party need not comply with any orders of that court. Failure to comply, therefore, cannot provide the ground for a sanction. In our view, petitioners are attempting to create a logical conundrum out of a fairly straightforward matter. Plaintiff/respondent Compagnie de Boutique de Guinee, CBG from here on, arranged to obtain various kinds of insurance, excluding excess insurance against business interruption. When such an interruption allegedly occurred and the insurers, including the excess insurers, refused to pay, CBG brought suit. The regular insurer did not contest jurisdiction, but the excess insurers, a group of foreign insurance companies, did. Plaintiff made certain requests for discovery in the action, which was brought in Pennsylvania Federal District Court. The excess insurers refused to comply on the grounds that the requests were too burdensome. CBG sought an order to comply, which the district court granted. A series of further moves failed to produce the required material. Finally, the district court warned the defendants that it would assume there was jurisdiction as a sanction pursuant to Rule 37 unless there was compliance. There was not, and the court entered an order finding in personam jurisdiction. 2. The validity of an order of a federal court depends upon that court's having jurisdiction over both the subject matter and the parties. The court discussed the nature of subject matter jurisdiction, including its non-waivability and the fact that it may be raised sua sponte by the court. None of this is true with respect to personal jurisdiction. The requirement that a court have personal jurisdiction flows not from Article 3 of the Constitution, but from the Due Process Clause. The personal jurisdiction requirement recognizes and protects an individual liberty interest. It represents a restriction on judicial power, not as a matter of sovereignty, but as a matter of individual liberty. Thus, the test for personal jurisdiction requires that the maintenance of the suit be offered traditional notions of fair play and substantial justice, quoting from International Shoe, which quoted Milken v. Myers. Because the requirement of personal jurisdiction represents, first of all, an individual right, it can, like other such rights, be waived. In McDonald v. Malby, the court indicated that regardless of the power of the state to serve process, an individual may submit to the jurisdiction of the court by appearance. A variety of legal arrangements have been taken to represent express or implied consent in the personal jurisdiction of the court. In National Rental versus Skunkcent, we stated that, quote, parties to a contract may agree in advance to submit to the jurisdiction of a given court, close quote. And in Petruski versus Hawkeye Security Company, the court upheld the personal jurisdiction of a district court on the basis of a stipulation entered into by the defendant. In addition, lower federal courts have found such consent implicit in agreements to arbitrate. Furthermore, the court has upheld state procedures which find constructive consent to the personal jurisdiction of the state court in the voluntary use of certain state procedures. Finally, unlike subject matter jurisdiction, which even an appellate court may review sua sponte under Rule 12H, Federal Rules of Civil Procedure, quote, a defense of a lack of jurisdiction over the person is waived, unquote, if not timely raised in the answer or responsive pleading. In sum, the requirement of personal jurisdiction may be intentionally waived, or, for various reasons, a defendant may be estopped from raising the issue. These characteristics portray it for what it is, a legal right protecting the individual. The plaintiff's demonstration of certain historical facts may make clear to the court that it has personal jurisdiction over the defendants as a matter of law, i.e., certain factual showings will have legal consequences. But this is not the only way in which a personal jurisdiction of the court may arise. The actions of the defendant may amount to legal submission to the jurisdiction of the court, whether voluntary or not. The expression of legal rights is often subject to certain procedural rights. The failure to follow these rules may well result in the curtailment of these rights. Thus, the failure to enter a timely objection to personal jurisdiction constitutes, under Rule 12H1, a waiver of the objection. A sanction under Rule 37B2A consists of a finding of personal jurisdiction has precisely the same effect. As a general proposition, the Rule 37 sanction applied to a finding of personal jurisdiction creates no more of a due process problem than the Rule 12 waiver. Although, quote, a court cannot conclude all persons interested by its mere assertion of its own power, end quote. and not all rules that establish legal consequences to a party's own behavior are mere assertions of power. Rule 37B2A itself embodies the standard established in Hammond Packing Company v. Arkansas 1909 case for the due process limits on such rules. There, the court held that it did not violate due process for a state court to strike the answer and render a default judgment against the defendant who failed to comply with a pretrial discovery order. Such a rule was permissible as an expression of, quote, the undoubted right of the lawmaking power to create a presumption of facts as to the bad faith and untruth of an answer begotten from the suppression of failure to produce the proof ordered. The preservation of due process was secured by the presumption that the refusal to produce evidence material to the administration of due process was but an admission of the want of merit in the asserted defense. It's a 1909 case. That's why it sounds all, Pride and Prejudice-y. The situation in Hammond was specifically distinguished from that in Hovey v. Elliott, an 1897 case, in which the court held that it did violate due process for a court to take a similar action as punishment for failure to obey an order to pay into the registry of the court a certain sum of money. Due process is violated only if the behavior of the defendant will not support the Hammond packaging presumption. A proper application of Rule 37b2 will, as a matter of law, support such a presumption. See Société Internationale v. Rogers, U.S. Supreme Court case from 1958. If there is no abuse of discretion in the application of Rule 37 sanction, as we find to be the case here, then the sanction is nothing more than the invocation of a legal presumption, or, what is the same thing, the finding of a constructive waiver. Petitioners argue that a sanction consisting of finding of personal jurisdiction differs from all other instances in which a sanction is imposed, including the default judgment in Hammond packaging, because a party need not obey the orders of a court until it is established that the court has personal jurisdiction over that party. If there is no obligation to obey a judicial order, a sanction cannot be applied for the failure to comply. Until the court has established personal jurisdiction, moreover, any assertion of judicial power over the party violates that party's due process. This argument, again, assumes that there is something unique about the requirement of personal jurisdiction which prevents it from being established or waived like all other rights. A defendant is always free to ignore the judicial proceedings, risk a default judgment, and then challenge that judgment on jurisdictional grounds in a collateral proceeding. By submitting to the jurisdiction of the court for a limited purpose of challenging jurisdiction, the defendant agrees to abide by that court's determination on the issue of jurisdiction. That decision will be res judicata on that issue in any further proceedings. As demonstrated above, the manner in which the court determines whether it has personal jurisdiction may include a variety of legal rules and presumptions, as well as straightforward fact-finding. A particular rule may be offered the due process standard of Hammond packaging, but the mere use of procedural rules does not in itself violate the defendant's due process right. The court concluded by finding that the sanction imposed by the district court was not an abuse of discretion under the facts of the case. Now I have Justice Powell, who concurs in the judgment. It is possible to read the court opinion not as affecting the state jurisdiction, but simply asserting Rule 37 of Federal Rules of Civil Procedure represents a congressionally approved basis for the exercise of personal jurisdiction by a federal court. On this view, Rule 37 invests the federal district courts with authority to take jurisdiction over persons not in compliance with discovery orders. This, of course, would be a more limited holding. Yet the court does not cast its decision in these terms, and it provides no support for such interpretation, either in the language or the history of the federal rules. In the absence of such support, I cannot join the court in embracing such a construction of the rules of civil procedure. There is nothing in Rule 37 to suggest that it is intended to confer a grant of personal jurisdiction. Indeed, the clear language of Rule 82 seems to establish that Rule 37 should not be construed as a jurisdictional grant. Quoting Rule 82, "These rules shall not be construed to extend to the jurisdiction of the United States District Courts or the venue of actions therein." Close quote. Moreover, assuming that minimum contacts remain a constitutional predicate for the exercise of a state's impersonal jurisdiction over an unconsenting defendant, constitutional questions would arise if Rule 37 were read to permit a plaintiff in a diversity action to subject the defendant to a fishing expedition in a foreign jurisdiction. A plaintiff is not entitled to discovery to establish essentially speculative allegations necessary to personal jurisdiction. Nor would the use of Rule 37 sanctions to enforce discovery orders constitute a mere abuse of discretion in such a case. For me, at least, such a use of discovery would raise serious questions about the constitutionality as well as the statutory authority of a federal court in a diversity case to exercise personal jurisdiction absent some showing of minimum contact between the unconsenting defendant and the forum state. In this case, the facts alone, unaided by broad jurisdictional theories, more than amply demonstrate the district court possessed personal jurisdiction to impose sanctions under Rule 37 and otherwise to adjudicate this case. I would decide the case based on this narrow basis of the factual predicate of the case. So he doesn't want to read the Rule 37 that way, so he's just like, the facts are enough, they have contacts, we're good. All right. Ready for a new one. Now we're on general and specific jurisdiction, which uses activities as a basis for jurisdiction. Helicopteros Nacionales de Colombia, SA versus Hall, 1983 U.S. Supreme Court case. Do a little something in the old lungs, and we'll press on. Justice Blackmun delivered the opinion of the court for this. Says, we granted certiorari in this case to decide whether the Supreme Court of Texas correctly ruled that the contacts of a foreign corporation with the state of Texas were sufficient to allow a Texas state court to assert jurisdiction over the corporation in a cause of action not arising out of or related to that corporation's activities within the state of Texas. Petitioner, Helicopteros Nacionales de Colombia S.A., we'll call it Helico from now on, is a Colombian corporation with its principal place of business in the city of Bogotá, in that country. Bogotá, in that country. Yeah, that's what I said. It is engaged in the business of providing helicopter transportation for oil and construction companies in South America. On January 26, 1976, a helicopter owned by Helico crashed in Peru. 4 United States citizens were among those who lost their lives in the accident. Respondents are the survivors and representatives of the 4 decedents. At the time of the crash, respondents' decedents were employed by Consorcio, a Peruvian consortium, and were working on a pipeline in Peru. Consorcio is the alter ego of a joint venture named William Sedeco Horn, WSH. The venture has headquarters in Houston, Texas. Consorcio had been formed to enable the ventures to enter into a contract with Puerto Rico, the Peruvian state-owned oil company. Oh, sorry, Puerto Rico, no. Into a contract with Peru. I don't know why I said Peru, a Peruvian state-owned oil company. Consorcio was to construct a pipeline for Peru, running from the interior of Peru westward to the Pacific Ocean. Peruvian law forbade construction of the pipeline by any non-Peruvian entity. Consorcio needed helicopters to move personnel, materials, and equipment into and out of the construction area. In 1974, upon request of Consorcio, the chief executive officer of Helico, Francis Restrepo, flew to the United States and conferred in Houston with the representatives of 3 joint ventures. At that meeting, there was a discussion of the prices, availability, working conditions, fuel, supplies, and housing. Restrepo represented that Helico could have the first helicopter on the job in 15 days. The Consorcio representatives decided to accept the contract proposed by Restrepo. Helico began performing before the agreement was formally signed in Peru on November 11, 1974. The contract was written in Spanish on official government stationery and provided that the residents of all parties would be Lima, Peru, and further stated that the controversies arising out of the contract would be submitted to the jurisdiction of the Peruvian courts. In addition, it provided that Consorcio would make payments to Helico's account with the Bank of America in New York City. Aside from the negotiation session in Houston between Restrepo and the representatives of Consorcio, Helico had other contacts with Texas. During the years of 70 to 77, it purchased helicopters, approximately 80% of its fleet, spare parts, and accessories for more than $4 million from Bell Helicopter Company in Fort Worth, Texas. In that period, Helico sent many prospective pilots to Fort Worth from training and to ferry the aircraft to South America. It also sent management and maintenance personnel to visit Bell Helicopter in Fort Worth during the same period in order to receive plant familiarization and for technical consultations. Helico received into its New York City and Panama City, Florida bank accounts over $5 million in payments from Consorcio drawn upon the First City National Bank of Houston. Beyond the foregoing, there have been no other business contracts between Helico and the state of Texas. Helico never has been authorized to do business in Texas and never has had an agent for the service of process within the state. It has never performed helicopter operations in Texas or sold any product that reached Texas. never solicited business in Texas, never signed any contract in Texas, never had an employee based there, never recruited an employee in Texas. In addition, Helico never has owned real property or personal property in Texas and has never maintained an office or establishment there. Helico has maintained no records in Texas and has no shareholders in the state of Texas. None of the respondents or the decedents were domiciled in Texas, but all of the decedents were hired in Houston by Consorcio to work on the Petro-Peru pipeline project. Respondents instituted wrongful death actions in the District Court of Harris County, Texas, that's in Houston, against Consorcio, Bell Helicopter Company, and Helico. Helico filed special appearances and moved to dismiss the actions for lack of in personam jurisdiction over it. The motion was denied. After a consolidated jury trial, judgment was entered against Helico on a jury verdict for $1,141,200 in favor of the respondents. And ruling that the Texas courts had in personam jurisdiction, the Texas Supreme Court first held the state's long-arm statute reaches as far as the due process clause of the 14th Amendment permits. Thus, the only question remaining for the court is to decide was whether it was consistent with the due process clause for Texas courts to assert in personam jurisdiction over Helico. 2. The due process clause of the 14th Amendment operates to limit the power of a state to assert in personam jurisdiction over a non-resident defendant, citing Pennoyer and Neff, 1878 jurisdictional civ pro case, really. Due process requirements are satisfied when in personam jurisdiction is asserted over a non-resident corporate defendant that has, quote, certain minimum contacts with the forum, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice, citing International Shoe versus Washington Company and Milken v. Mayer. When a controversy is related to or arises out of a defendant's contacts with the forum, the court has said that a relationship among the defendant, the forum, and the litigation is essential to the foundation of in personam jurisdiction, citing Schaefer v. Hittner. Even when the cause of action does not arise out of or relate to a foreign corporation's activities within the forum state, due process is not offended by a state subjecting the corporation to its in personam jurisdiction where there are sufficient contacts between the state and the foreign corporation, citing Perkins v. Benguet, Consolidated Mining Company, and Kenton versus Hustler Magazine Incorporated. In Perkins, the court addressed a situation in which state courts had asserted general jurisdiction over a defendant foreign corporation. During the Japanese occupation of the Philippine Islands, the president and general manager of the Philippine Mining Corporation maintained an office in Ohio from which he conducted activities on behalf of the company. He kept company files and held directors' meetings in the office, carried on correspondence relating to the business, distributed salary checks drawn from 2 active Ohio bank accounts, engaged an Ohio bank to act as a transfer agent, and supervised policies dealing with the rehabilitation of the corporation's properties in the Philippines. In short, the foreign corporation, through its president, had been carrying on in Ohio contiguous and systematic but limited part of its general businesses. And the exercise of general jurisdiction over the Philippines corporation by an Ohio court was both reasonable and just. All parties to the present case concede that respondents' claims against Helico do not arise out of and are not related to Helico's activities in Texas. We must therefore explore the nature of Helico's contacts with the state of Texas to determine whether they constitute the kind of continuous and systematic general business context the court found to exist in Perkins. We hold that they do not. It is undisputed that Helico does not have a place of business in Texas and never has been licensed to do business in the state. Basically, Helico's contacts with Texas consist of sending its chief executive officer to Houston for contract negotiation sessions, accepting into its New York bank account checks drawn from a Houston bank, purchasing helicopters equipment and training from Bell Helicopter for substantial sums, and sending personnel to Bell's facilities in Fort Worth for training. The one trip to Houston by Helico's chief executive officer was for the purpose of negotiating the transportation services contract with Consorcio, cannot be described or regarded as a contact of a continuous and systematic nature, as Perkins describes it. Also see International Shoe, and it thus cannot support an assertion of in personam jurisdiction over Helico by a Texas court. Similarly, Helico's acceptance of the Consorcio of checks drawn on a Texas bank is of negligible significance for purpose of determining whether Helico had sufficient contacts in Texas. There is no indication that Helico ever requested that the checks be drawn on a Texas bank or that there was any negotiation between Helico and Consorcio with respect to the location or identity of the bank on which checks would be drawn. Common sense and everyday experience suggest that, absent unusual circumstances, the bank on which a check is drawn is generally of little consequence to the payee and is a matter left to the discretion of the drawer. since unilateral activity of another party or a third person is not appropriate consideration when determining whether the defendant has sufficient contacts with a foreign state to justify an assertion of jurisdiction, see Clunko versus California Supreme Court, 1978, where it was arbitrary to subject one parent to a suit in any state where the other parent chose to spend time while having custody of any children pursuant to a separate agreement. Also, the unilateral activity of those who claim some relationship with a non-resident defendant cannot satisfy the requirement of contact with a foreign state. The Texas Supreme Court focused on the purchase and the related training trips to find contact sufficient to support an assertion of jurisdiction. We do not agree with that assessment for the court's opinion in Rosenberg Bros. And Company versus Curtis Brown Company in 1923. Justice Brandeis, for a unanimous tribunal, made clear that the purchase and related trips standing alone are not a sufficient basis for a state's assertion of jurisdiction. The defendant in Rosenberg was a small retailer in Tulsa, Oklahoma, who dealt in men's clothing and furnishings. It had never had applied for a license to do business in New York, nor had it at any time authorized suit to be brought against it there. It never had an established place of business in New York and never regularly carried on business in that state. Its only connection with New York was that it purchased from New York wholesalers a large portion of the merchandise sold in its Tulsa store. The purchases sometimes were made by correspondence and sometimes through visits to New York by an offer of the defendant. The court concluded, quote, visits on such business, even if occurring at regular intervals, would not warrant the interference that the corporation was present within the jurisdiction of New York. This court in International Shoe acknowledged and did not repudiate its holding in Rosenberg. In accordance with Rosenberg, we hold that mere purchases, even if occurring at regular intervals, are not enough to warrant a state's assertion of in personam jurisdiction over a non-resident corporation in a cause of action not related to those particular purchase transactions. Nor can we conclude that the fact that Helical sent personnel into Texas for training is in connection with the purchase of helicopters and equipment in that state is any way enhanced by the nature of Helical's contact with Texas. The training was a part of the package of goods and services purchased by Helical from Bell Helicopter. The brief presence of Helical employees in Texas for the purpose of attending the training sessions is no more significant contact than were the trips to New York made by the buyer for the retail store in Rosenberg. 3. We hold that Helical's contact with the state of Texas were insufficient to satisfy the requirements of the Due Process Clause of the 14th Amendment. Accordingly, we reverse the judgment of the Supreme Court of Texas. Justice Brennan dissented. So we have two parts of Justice Brennan's dissent, and then we'll be done. So Brennan doesn't agree. Let's see why he doesn't agree. The court expressly limits its decision in this case to an assertion of general jurisdiction over a foreign defendant. Having framed the question in this way, the court is obliged to address our prior holdings in Perkins v. McGrest, Consolidated Mine Company, and Rosenberg Bros. V. Curtis Brown Co. In Perkins, the court considered a state's assertion of general jurisdiction over a foreign corporation that had been carrying on a contiguous and systematic but limited part of its general businesses in that forum. Under the circumstances of that case, we held that such contacts were constitutionally efficient to, quote, make it reasonable and just to subject the corporation to that jurisdiction. Nothing in Perkins, however, suggests that continuous and systematic contacts are necessary minimum before a state can constitutionally assert a general jurisdiction over a foreign corporation. The court therefore looks for guidance to our 1923 decision in Rosenberg, which until today was of dubious validity given the subsequent expansion of personal jurisdiction that began with International Shoe. The vast expansion of our national economy during the past several decades has provided the primary rationale for expanding the permissible reach of the state's jurisdiction under the Due Process Clause. By broadening the type and amount of business opportunities available to participants in interstate and foreign commerce, our economy has increased the frequency with which foreign corporations actively pursue commercial transactions throughout the various states. In turn, it has become both necessary and, in my view, desirable to allow the states more leeway in bringing the activities of those non-resident corporations within the scope of their respective jurisdictions. As a foreign corporation that has actively and purposefully engaged in numerous and frequent commercial transactions in the state of Texas, Helical clearly falls within the category of non-resident defendants that may be subject to that foreign state's general jurisdiction. Helical not only purchased helicopters and other equipment in the state for many years, but sent pilots and management personnel to Texas to be trained in the use of this equipment and to consult with the seller on technical matters. Moreover, negotiations for the contract under which Helical provided transportation services to the joint venture that employed the respondents' descendants also took place in the state of Texas. Taken together, these contracts demonstrate that Helico obtained numerous benefits from its transacting of business in Texas. In turn, it is eminently fair and reasonable to expect Helico to face the obligations that attach to its participation in such commercial transactions. Accordingly, on the basis of continuous commercial contact with the forum, I would conclude that the Due Process Clause allows the state of Texas to assert general jurisdiction over the petitioner Helico. Section 2, he says, this is simply not a case, therefore, in which a state court has asserted jurisdiction over a non-resident defendant on the basis of wholly unrelated contacts with the forum. Rather, the contacts between Helico and the forum are directly related to the negligence that was alleged in respondent Hall's original complaint. Because Helico should have expected to be amenable to a suit in Texas, courts for claims directly related to these contacts, it's fair and reasonable to allow the assertion of jurisdiction of this case. Limiting the specific jurisdiction of a forum to cases in which the cause of action formally arose at a defendant's contact with the state would subject constitutional standards in the Due Process Clause to the vagaries of some substantive law and pleading requirements of each state. For example, the complaint filed against Helico in this case alleged negligence based on pilot error. Even though the pilot was trained in Texas, the court assumes that the Texas courts may not assert jurisdiction over the suit because the cause of action, quote, did not arise out of nor is related to that training. If, however, the applicable substantive law required that negligent training of the pilot was a necessary element for the cause of action of pilot error, or if the respondent had simply added an allegation of negligence in the training provided for the Helico pilot, then presumably the court would concede that it did have specific jurisdiction and that Texas's ruling was applicable. Our interpretation of the Due Process Clause have never been so dependent upon the applicable substantive law or the state's formal pleading requirements. At least since International Shoe, the principal focus when determining whether a forum may constitutionally assert jurisdiction over a non-resident defendant has been on fairness and reasonableness to the defendant. To this extent, a court-specific jurisdiction should be applicable whenever the cause of action arises out of or relates to the contacts between the defendant and the forum. It is eminently fair and reasonable, in my view, to subject the defendant to suit in a forum with which it has significant contacts directly related to the underlying cause of action. Because Helico's contact with the state of Texas meet the standard, I would affirm the judgment of the Supreme Court of Texas. That was a mouthful. So that's for that. Now we'll go, later this week, we'll go to Burnham versus Superior Court of California, 1990, Scalia opinion. Still about jurisdiction, though. We'll also, on I think it's, Tuesday night, we'll do Bristol Myers Squibb versus Superior Court. 2017 Supreme Court case. And then we'll probably do a third case, maybe. Nope, just those two. Wait. No, I lied. A third case for next time, too. BNSF Railway Company versus Tyrell, a Supreme Court case from 2017. So that's what we have on tap next time, folks. Still dealing with activities as basis for the jurisdiction. So basically, one of the parties, usually the defendants, activities within the place they were sued as a basis to give the court in that forum where they're being sued jurisdiction to rule over them. So we're dealing with different ways that the Supreme Court has dealt with that, but still activities as a basis for jurisdiction next time. All right, you have a blessed one. Tip your bartenders, tip your waitresses. Don't drunk drive. No kicking dogs either. Or if you were going to do that. Love y'all. Night night.